Right, so one of the most popular questions on delegated legislation looks at the controls, right? And it's very common for students to get confused between the types and the controls. The idea of controls is that if we are giving away power with delegated legislation, Parliament have got to control that power. Yeah, so in other words, it's making sure that these bodies that we're giving this power to don't take the mick. So it's the same example that I always use. If, say, my head of school was giving me a job to do, she just won't give me a job and then not actually check up on that I've done that job and I've done it well, or I've done it how that she wanted it to be done. And it's exactly the same as Parliament. If Parliament are giving other people power to make laws, they will control that power in some way, whether they'll check up on them, whether they'll give them a list, whichever way. So it's controlling and it's checking. And ultimately what we don't want to happen is we don't want that piece of delegated legislation, that body who's been given that power, to do something known as ultra vires. And ultra vires means when they go beyond that power. So, stupid example, you give the Minister of Transport the power to make some road signs and he makes a road. Yeah, that would be ultra vires, because ultimately he's done something completely different than what he was told to do. Right, now there's two people who can control what these bodies do: Parliament and the courts. So first of all, if we're looking what controls are out there that Parliament do. Now bear in mind, Parliament are the ones that are giving away the power. Of course they're going to check up on these bodies, of course they're going to control it somehow. And the easiest way, and one of the ways that I think is ultimately most effective, is something called the Enabling Act, right? Which is basically a list, right? So it's like anything. Pretend your mum's going to give you a list of jobs to do around the house. If she just said to you, right, clean the house, the likelihood is you're either not going to do it or you're not going to do it properly. But if she gives you a list of everything that she wants you to do, so she might want you to tidy the bedroom, she might want you to put your clothes away, she might want you to put the washing on, she might want you to wash the bathroom. If she gives you an actual list, then that is so much more effective than just saying tidy the house. And it's exactly the same as Parliament. If Parliament give away power and just say do this, the likelihood is that it's either going to be wrong, they're going to do something that they're not supposed to. But if they give them what is known as an Enabling Act, i.e. a list of everything that they've got to do, then the likelihood is that they're not going to create an ultra vires action, right? So as it says down there, it's an act of Parliament that will define the nature and the scope. In other words, it's a list of everything they've got to do, how they've got to do it. Sometimes in those lists, it'll actually tell them that they have to consult certain people, right? So, for example, if we're looking at, say, Minister of Transport, right, it might say you have to do this, you have to do that, you have to consult this people, you have to do that, you have to have this meeting. So basically, very clearly, very precisely telling them exactly what they've got to do, right? And ultimately, that is probably one of the most effective controls, because it's been clear and it's Parliament knows that they've done that, and also the body who's been delegated that power have basically got a checklist on there and say, right, this is everything that I've got to do. Now, the other control, number 2, that they've got is how this delegated legislation is made. And again, we've mentioned this before. So they have different resolution procedures, right? And this is how it's introduced. And ultimately, there are 3 different types, right? There is a negative one. Now, the negative resolution procedure is probably the most lenient. So in other words, all it happens is that once that body has made it, they'll put a notice up in Parliament, and that notice will go up for 40 days. If nobody objects within them 40 days, it automatically becomes law. If someone objects and says, hold on a minute, I don't think that's right, then it'll be debated in Parliament, right? So again, that is another control. Why is it another control? Because it's another checking. There's the opportunity for Parliament to check that piece of delegated legislation. Now, if the area is more crucial or more controversial or a bit more complex, then the likelihood is that that piece of delegated legislation will go through an affirmative or a super affirmative. Now, an affirmative resolution procedure is when that body has made that law, it has to be checked by Parliament. And again, why is it control? Well, because it's clearly control. It's saying, right, you do this, but before you do it, I'll check it first. So it's like, for example, if my head of department gave me a job to do and said, right, before you send that letter off that I've asked you to do, give it to me. I'll check it first before you send it off. And that's exactly what an affirmative resolution procedure is. So Parliament give away power, but say, right, before it becomes law, I'm checking it first. And then a super affirmative, it's when it's very controversial, there may be an element of it that is very complicated, and it basically means a super affirmative that a Parliament do like a super duper check. So they've got extra powers to review it. They might review the process of it. They might review it when it's done. But again, it's an area where they will double check it before it becomes law. Right? And then the last parliamentary control is something known as the Scrutiny Committee. Right, and I always think it must be a very boring job to be part of the Scrutinist Committee, because all it is a group of MPs or members of the House of Lords whose their job is to basically check through every piece of delegated legislation, right? And again, it's a check-in. So again, I always use the example of my work, right? When we all create references for students, those are checked by our heads of department before they're given to students. Yeah, and it's exactly the same as the Scrutiny Committee. Once the piece of delegated legislation is done, the Scrutiny Committee will basically go through all the pieces of delegated legislation and check they're all right. Again, if there's an issue, so if they pick one up that they think, oh, that's a bit dodgy or there's something wrong about that, then they will report back to Parliament and say, look, I think there's an issue with this. Right? Now, as well as Parliament controlling it, we also can have the courts control delegated legislation. But the problem with the courts controlling it is that this is after the piece has been made into law. So all the other checks are generally how it's made, before it gets made, etc. Whereas the courts can only check it after it's become law and if it's impacted somebody. And one of the big problems with the idea of the courts controlling it is that it relies on the person who's potentially been affected. And what it's called a judicial review. And again, easy way to remember it, they're basically reviewing a piece of law. That's what it's called, judicial review. So, if, for example, again, and this is why it can be criticised, if a person, a citizen, thinks they've been affected by a bad piece of delegated legislation, they can go to the High Court, the QBD, Queen's Bench Division, and basically ask for a judicial review. So they'll turn up to court and say, look, I've been affected by this piece of delegated legislation. I think there's something wrong. I don't think it's right. I want you to check it for me. Right? That judicial review will ultimately mean that the judges will go through it and check. Now, whilst they're checking that, maybe there's something wrong with it, it's ultra vires, whatever, the court will issue what is known as an injunction. Right? So because it's under review, it's temporarily stopping the law, because at the end of the day, there's no point in it continuing if it actually is bad, because it'll affect more people. So I go to court, I say, look, I think I've been affected by a bad piece of delegated legislation. They'll say, right, yeah, we will review it. Immediately they'll put an injunction on it, so they'll stop it temporarily. And then they will check this piece of delegated legislation. Now, they might check it and might think, oh, actually it's perfectly fine, there's no issues with it. Or they could find an issue with it. And that issue could be several things. The first thing it could be is something known as procedural ultra vires. Now bear in mind, we know what ultra vires means, i.e. it means going beyond the power. If it's procedural ultra vires, it means that when they've gone beyond the power, it's been something to do with the process, the procedure of making the law. Right? And the best example is that Aylesbury mushroom case, to do with the Mushroom Growers Association. So basically, the body was told to make this law, in the Enabling Act, so remember your list, it says specifically you had to consult mushroom growers, right? So when this law was being made, they had to do that. They failed to do that, so they failed to consult the Mushroom Growers Association. Therefore, the court held that this was procedural ultra vires, i.e. the process that it's been made is not correct, right? And that's why it's procedural, right? So generally this will cover people not being consulted, it's not being made in a certain way. In other words, when they made it, something wasn't correct, right? Now, the second type is something known as substantive, and I always remember the idea of the end result, right? So it's not that the process of making it was wrong, it's the end result is wrong, right? And generally that could be that the end result is imposing a tax because they're not allowed to do it, or probably the most easiest one to remember is that it's completely different to what they've been told to do. So again, my stupid example is, you're the Minister of Transport, you've been told to make some road signs, you make a road, right? That end result is wrong. Therefore, because that end result is wrong, it's substantive ultra vires, right? And there are two examples, case examples down there. Again, obviously, the problem is with these case examples, they're very long named. You wouldn't be expected to remember the full name. So again, for example, the second one, if you said, oh, the Fire Brigade's Union case, and said, oh, this is when the Home Secretary went beyond their powers, so the end result was wrong, so it's substantive ultra vires, that would be completely fine, right? So don't worry about the precise wording. Remember, it's quite flexible in that some sort of case name and then the point of that case, right? Now, there's also another type of substantive ultra vires, which is known as unreasonable, right? In other words, what they're basically saying is the whole thing's just ridiculous, right? So the whole thing's unreasonable, whether it's part of it's unreasonable, part of it's ridiculous, or the whole thing is just absurd, then that will also be ultra vires. And the case example that we did, again, you wouldn't need to remember the full case name, so you could remember just the word Strickland. This was to do with that the council tried to ban singing of obscene songs, right? And then what happened was that a few people got together, went to the High Court to ask for a judicial review and just said, look, I think this is ridiculous. This council's trying to ban this. I think it's ridiculous. They did the judicial review and they did say, yeah, you're completely right, this is unreasonable ultra vires. So it's gone beyond the power because it's just a ridiculous law. The other example I always give is it's like saying, right, Wakefield Council has decided to ban everybody under the age of 18 cannot be allowed out after 7 o'clock at night. Yeah, that is unreasonable, that's ridiculous, so therefore it will be declared ultra vires, right? And then the last thing to mention is to do with if it conflicts with human rights. Again, if it conflicts with human rights, then it can be classed as void as well. Now, at the end of it, so like I say, at the end of this review, the judges will check it all. They either say it's fine, they either say it's procedural ultra vires, they either say it's substantive ultra vires, they either say it's unreasonable. At the end of that, then they've got to do something with it. You can claim compensation if you've been affected by a bad piece of delegate legislation. And also, they've got to do something with it. So they can't just say, right, oh yeah, it's bad, and then leave it. So either they'll amend it, they'll scrap it, parts of it will be temporarily stopped and then altered. So they'll actually kind of issue a decision on the basis of, right, Parliament, you've got to do something about this because it's wrong.